Whenever you're ready.
Good morning. My name is Angela Brown, and I represent the appellants in this matter, Alliance Family of Companies, and Mr. Justin Magnuson. May it please the Court. Arbitration agreements are creatures of contract, and as such, they are amenable to the traditional contract principles of interpretation. The agreements before the Court today are very similar and fall under the same principles. So why are we here today? We're here today because Ms. Navarez's underlying allegations evoke an emotional response. The way she has pled her case is alarming. Sexual assault in the workplace is a serious matter. But the emotional, visceral response that we get from reading her petition, we have to think about instead pulling back and looking at traditional principles of contract interpretation. Second, Ms. Navarez has pled her case in an unusual way. She alleges that she was at her workplace, that her supervisor was acting within the course and scope of his employment, and third, that her employer, who she holds directly liable for the assault, failed to provide her with a safe workplace. And yet, all of these actions are unrelated to her work with Alliance. Instead of relying on traditional contract interpretation, Ms. Navarez tries to lead this Court to an end run and asks the Court to apply a subjective test, basically asking the Court a number of occasions to say, would anyone have agreed to this provision in the contract? That's just not the law.
Do we treat narrow scope clauses differently than broad scope clauses? And is this a narrow scope or a broad scope clause?
Absolutely. They are treated differently, and the courts have traditionally looked at clauses different ways. What we have here is a broad clause in the contract, and so any work done by Ms. Navarez, we have two agreements here. So any work.
Why is this a broad scope clause?
Because it relates to any work that she has done with Alliance and with Mr. Magnuson. So let me explain. In Section 5 of the agreement, it says that any dispute arising under this agreement is amenable to arbitration. It must be read in conjunction with the recitals, the definitional section that the parties agreed to, which says that under this agreement means any work done by Ms. Navarez. Now, there are two agreements, one with Mr. Magnuson and one with Alliance.
They're both non-disclosure agreements.
The title is non-disclosure.
Agreements. These are non-disclosure agreements.
Yes, Your Honor. And typically in the employment context, as you know, these types of agreements come up all the time with different names.
What is it exactly? What is the confidential information you say she cannot disclose or did in violation of the agreement?
Well, we're not here today because she disclosed confidential information. We're not bringing the lawsuit. In fact,
I understand that, but what is it that she is disclosing under this non-disclosure agreement that brings her sexual assault case within the apparently broad reach of this provision?
I understand the question. This non-disclosure agreement works more as an employment contract. Because the parties have defined the agreement, and I'll quote here, all work done by contractors shall be in the course and scope of this agreement. This agreement covers more than just a disclosure. In fact, that's buttressed by the fact that in Section 6 of the agreement, any non-disclosure issues need to go or give Alliance and Mr. Magnuson the ability to go get an injunction. So this agreement covers more than just any disclosure of not.
Don't we have some case authority out there from this court about how we treat recitals in contracts?
Well, Your Honor, yes, and typically recitals are not part of the contract, but here, when we see that the parties have agreed to the language in the contract, we need to take that into account. Truthfully, it is a recital in that it has the word whereas in front of it, but the parties here have defined the terms. It is a definition, and so the parties have said any work done by Ms. Navarez is under this agreement.
Under the confidentiality provisions?
No, under the arbitration provisions. So if we look at Section 5 of the agreement, it says, Any dispute under this agreement, other than as provided for paragraph 6, and that was the injunction provision I'm talking about, shall be subject to the following process. In the recitals, which really is a definitional section, it says, all work done by contractor shall be in the course and scope of this agreement. That recital, that definition, brings this into more of an employment agreement and expands the scope of the arbitration clause.
Where does this, I'm still not comprehending how her claims fall within this.
Well, Ms. Navarrete, I agree with you. This is awkward, and it was pled awkwardly. Typically, sexual assault would not fall within someone's scope of work, but this is how she pled it. She said she was called to Mr. Magnuson's home. This is her normal place of employment. This is what she says in her petition. Then she says Mr. Magnuson was acting within the course and scope of his employment with Alliance. And then she says that Alliance is directly responsible for this attack because they failed to provide a safe work environment. All of that is her employment, is her work, and therefore falls under the agreements here. That's how it relates to her employment, because she said it did. So when we look at normal contract principles, and we're looking at whether or not Alliance and Mr. Magnuson have met their burdens here, there's a two-part inquiry. Whether there's a valid enforceable agreement, whether the dispute here falls within the agreement, which is what you've been asking about, and whether Ms. Navarrete has pled and sufficiently shown an affirmative defense. Here, Alliance and Mr. Magnuson have offered in evidence a written agreement. It was signed by Ms. Navarrete. There's evidence in the record that Mr. Magnuson saw her sign it. We have an offer, an acceptance, mutual promises of arbitration. That is sufficient under the case law to have a binding, valid contract here. If we turn to the scope of the agreement, as we were discussing before, when we read the four corners of the document and we give effect to every provision in the contract, it is understandable that the arbitration clause has been expanded to encompass the work done by Ms. Navarrete. And those are the traditional principles of contract law that we need to look at. And as you know, arbitration agreements should be read as broad as possible, and that's what we have here. You may be asking, can sexual assault ever be part of someone's employment? And the answer to that is yes. Case law, particularly under the FAA, these cases have come before the court before, and sexual assault has been arbitrated. Within the state of Texas, we cited to the case of IFMG versus Sewell, which is out of Corpus Christi, which cited the Jones versus Halliburton case, which also arbitrated Ms. Sewell's sexual assault case. In her petition, Ms. Sewell alleged assault, actual sexual assault, very similar to what we have here, in that it was sexual assault. So these claims can be arbitrated. It's not against public policy to arbitrate these kind of claims.
Does our court have any authorities dealing with whether a rising under clause is a narrow or broad clause?
Well, traditionally, a rising under is the more narrow of the two. So related to, arising out of, one is broader than the other. And so what we're saying today is we've got the broadest clause possible, because although it says under this agreement, arising under this agreement, we have the definitional section which says any work that she does is related to this agreement. So falls under this agreement. So any work expands the scope of the arbitration clause here.
So notwithstanding the fact that this is a narrow clause agreement, we're supposed to read it as a broad clause agreement.
I would disagree and say this isn't a narrow clause agreement. I would say that this is contains some of the language that courts have said were narrow in the past, but given the definitional section, given what the parties have agreed to here, and again, we have to look at the document as it is. We have to look at the four corners of the document and give meaning to each phrase. The parties chose this language. Ms. Navarrete has agreed to this language. The language in the contract is if it's related to her work, it falls under the agreement.
Tell me once again, maybe it's a rough morning, how her claims, as pled, fall into confidential information that implicates a nondisclosure agreement.
I don't believe that it does, and that's because what we're saying is that the arbitration agreement, although it's found in a document that is entitled nondisclosure, is really an employment agreement because of the language that the parties have chosen.
When it doesn't have terms you would normally find in an employment agreement like duration, duties, compensation, non-competes.
Or even the phrase arising out, all claims arising out of the employment relationship.
It does.
It does not
right.
have that.
It does not. It does not. And what it has is that the phrase, all work done by contractor shall be in the course and scope of this agreement. And it is not a non-compete. It is not traditional non-compete. It doesn't have to have how much she's going to be paid and duration. It does have the expectations of work. It does have the expectations that Ms. Navarez will be given confidential information and that she has promised not to disclose that information. But again, it's more expansive. When we look at, if we look just for an example, at the contract with Mr. Magnuson, and here I'm looking at, there's various, multiple copies of this within the record, but I'm looking at the second supplement that the clerk gave to the court, and this is on page 18. JM has requested the contractor to provide services as a personal assistant. So we have a description of what she's going to do for Mr. Magnuson.
But that doesn't tell us anything, does it?
It does. It tells her what the expectations of her employment are.
Well, that would be with any job.
Well, when we look at that clause, we look in terms of the confidential information that you were talking about, and that provides us with an even more expansive definition. If we take a look at specifically with Mr. Magnuson, traditionally you wouldn't think that personal information would fall under an employment agreement, but here the definition of confidential information includes Mr. Magnuson's personal life.
That's where this is headed, right?
What do you mean? I'm sorry.
That's where this is headed. The ultimate aim here is to prevent her from testifying in any forum because of this nondisclosure agreement.
Absolutely not. No. She can testify in front of the arbitrator. She has the full panoply of rights in an arbitration.
Wouldn't this prevent that? Your interpretation of it, wouldn't it prevent that?
The only thing
is that disclosing his personal information?
No, because it forces it to arbitration. Any disagreement under this contract.
The nondisclosure agreement is only valid in the operates differently in arbitration. I mean, it's either a nondisclosure agreement or it's not.
I understand your question now. So what we're saying is that, again, this isn't just a nondisclosure agreement. This is an employment agreement. And because it's an employment agreement, she could compel them to arbitration as well. And that is what we're talking about here, is we're talking not necessarily about a disclosure of information. We're talking about a term of things related to her work and the fact that she has signed agreements that say that she will submit any claim that she has related to her work to arbitration. And this is a claim related to her work. And I understand the consternation. I get it. Because this is awkward. It is because she has pled it this way.
Well, what's awkward is I don't see that last phrase you just quoted to us, just cited us. Any claim she may have arising to her, from her employment should be submitted to arbitration. Where is that? I can't for the life of me find that.
I understand. When you look at, I think I'm going to repeat myself here, which is.
Yeah, I'm just not.
This is where I want you to go. So when we talk about the agreement itself, and yes, it comes within the guise of a non-disclosure agreement. When we talk about the agreement, the parties have agreed to define the agreement as any work done by Ms. Navarez. That changes it to an employment agreement. Its name is irrelevant at this point because it covers more. And while I understand, how does this come up in a non-disclosure? Again, we didn't plead the case this way. She did. She told us that she was at her workplace. She told us she was within Mr. Magnuson was acting within the scope of his employment, and then she seeks, with an intentional tort, to hold the company directly liable for the actions of Mr. Magnuson, and yet says this is not related to her work. That's the confusion. That's the awkwardness. We didn't plead it this way. We have to take her allegations as true. As vehemently as we deny this, we have to take them as true. Is there a more plausible explanation for what happened? Absolutely. But that's not what we have in front of us. All we have is her petition and what she has said. If we turn to the issue of unconscionability, Ms. Navarez has not pled procedural unconscionability. She simply said this was substantively unconscionable, basically saying that the term itself is unfair. And this is where we get the invitation to the dance, if you will. No one would ever agree to this provision. Well, that's not the question. The question is there a valid agreement? Does it fall within the scope of the agreement and the language with which the parties agreed to? Here, we have a traditional arbitration clause, mutual exchanges of agreement to arbitrate, both sides giving up rights to a jury and to have the forum change to an arbitration. That's enough. That's enough for a contract. It's for us to decide whether it's in the scope. But it's not an invitation to read a new rule into the contract law. Foreseeability is something that we want to stay away with in contracts. And when agreements fall within a particular scope of a contract, it's really immaterial whether it was foreseeable. If we had foreseeability as a new provision way to read contracts, your job would be a lot harder because we would be here all the time subjectively trying to figure out what did the parties actually mean. And here's an invitation to go even further and say, not just the parties didn't agree, but no one would ever agree. That's just not how it works. So this is not unconscionable. She has not proven her affirmative defense, and therefore the contract should have been enforced, and the district court erred when it failed to compel arbitration here.
Anything else? Thank you very much. I don't think this is going to be a problem here today, but I should have told you all that if you need the podium to go up or down, there's a switch that has been conveniently provided on this podium that will allow it to go up or down.
Thank you, Your Honor. Good morning, Your Honors. Thank you. May it please the Court. My name is Matthew Kita. I represent the appellee, Jamisha Navarez. Your Honor, the sum of the appellant's argument here is that because Ms. Navarez seeks to hold AFC liable, that therefore it must have arisen out of the course and scope of her employment, and because it rose out of course and scope, the arbitration clause must be effective. We respectfully disagree. In our brief, we had numerous arguments that had to do with waiver and whether there was a meeting of the mind or evidence of consideration. I assume that's not why you asked us to come down here and argue today. I'd like to respond directly to the arguments about what is the scope of this particular agreement, and assuming that, without conceding that it could cover this type of behavior, is it substantively unconscionable? And I'll stick to those points unless Your Honors have questions about the others. Opposing counsel began by noting that arbitration clauses are creatures of contract, and we wholly agree with that. So let's take a look at what this contract specifically relates to. It discusses disputes that arise under this agreement must be arbitrated. And what the agreement refers to are services, work, assistance that she provides, the needs of AFC, and work paid for by AFC. Quite obviously, it does not involve the intentional torts of its principals or vice principals. And arguing that something is outside of this course and scope because it involves criminal conduct is a truism, not really an argument, because no business is in the business of committing crimes or inflicting intentional torts on its employees. That does not mean that the law has said that principals of corporations or vice principals of corporations or officers of corporations cannot put the company treasury at risk when they commit those type of acts in the workplace. And that's a good thing. It's a good thing that the company is at risk when the officers and principals and vice principals of a corporation assault their employees, because it gives them a firm incentive not to do so. to suggest that somehow someone can do this type of thing, can bring someone into the workplace, take advantage of them in a criminal matter, and then say, oh, well, it's just my personal liability that's at stake, not the place that you came thinking that you were coming here to work. There's no public policy justification for that whatsoever. What makes sense in this regard of having an arbitration agreement for someone who serves as a personal assistant is that in the event that there is a dispute over the disclosure of confidential information or the work that she's providing for a very high-level employee at a prestigious corporation, is to ensure that if there is a dispute that the information was leaked or that the services were not properly performed or some such, that it wasn't put in a pleading and filed as a matter of public record in a Dallas County court.
If she had been invited over for the purpose of being handed the company's secret formula when this happened, would the dispute arise under the contract?
Okay, if she had been invited over and was sexually assaulted, or she was invited over and lost it, or decided to read it to the Dallas Morning News, or gave it to a competitor. I mean, the fact that he invited her over ostensibly under the guise of you're doing your work right now.
For the specific purpose of giving her the secret formula for her to go do something with when she leaves.
Okay. But where is the tortious conduct that would give rise to a dispute?
While she's at his house.
A sexual assault occurs?
Yeah, he's handing her the formula and then decides to engage in the alleged conduct.
Well, assuming that the complaint would be arising out of non-consensual sexual activity, that clearly has nothing to do with the services, work, or assistance that she's providing. The fact that we have a unique circumstance that requires this particular personal assistant to go to the home of her employer is irrelevant. Okay? The fact that people that worked for NBC went to the office of Matt Lauer and were sexually assaulted, NBC was on the hook for that, as well as him personally. The fact that they didn't...
We're not discussing liability here. We're discussing the scope of an arbitration agreement.
That's exactly correct, Your Honor. And the scope of the arbitration agreement should be read narrowly to the terms of the agreement. This arises out of her work or her services or her assistance, not any type of extracurricular, whether consensual or non-consensual, that would go along with. If he had gone to her office, if she had gone to his home and she had stolen objects from his apartment, was there any reasonable expectation that if he sued her for conversion that she could enforce this arbitration agreement? To say, no, you committed a criminal activity at my home.
This would be a different case if he invited her over simply on a social visit to have Sunday brunch.
Correct.
But this was a business invitation, wasn't it?
Well, the invitation was under the guise of doing business, but once the business stopped, so did the scope of the arbitration agreement. And I think that's what the important case here, and I think it's referenced in both my brief and the appellant's brief, is the Jones versus Halliburton case. And Jones versus Halliburton was a Fifth Circuit case, which is certainly hardly the haven or bastion of left-leaning jurisprudence. In that particular case, a woman was stationed was working for Halliburton in Iraq. She was housed in Iraq. She was required to work there. And the Fifth Circuit, when she claimed that she was gang raped by 20 of her employees, she sued her on numerous causes of action, including assault and battery, intentional infliction of emotional distress, negligent hiring, false imprisonment, all seeking to hold the corporate treasury liable under a vicarious liability theory. And the court said that some of your claims are arbitrable, but these ones that involve specifically out of the sexual assault are not. Why? Because they're not related to her employment, and they did not arise in the workplace. Even though she was required to live with these people, they said they did not arise in the workplace. This wasn't her boss summoning to her house. This happened in her home, and the home that Halliburton paid for. They basically said that look at the provision at issue, and they say if the provision at issue only talks about the claims related to your employment or personal injuries arising in the workplace, you are not in the workplace when you are being penetrated by one of your coworkers, or in this particular case, your boss. The workplace stops, and this is a direct quote from the Fifth Circuit, the workplace stops at her bedroom door, even though her bedroom door was at Halliburton's workplace there. Now, the Fifth Circuit cited cases from Mississippi, Kentucky, California, and West Virginia, all of which have held that arbitration clauses do not apply to this conduct for substantive unconscionability reasons. The Fifth Circuit held that, and this court should follow suit. Quoting directly from the...
What would happen if this were a broad related to clause?
Excuse me, please?
What would happen if this were a broad related to clause?
Your Honor, I don't think there's any circumstance ever where a sexual assault should be subject to an arbitration. A claim for civil damages for sexual assault should be subject to a secret proceeding. There's no conceivable public policy rationale for that. And the idea...
Is it a public policy issue or is it a contract issue?
Your Honor, respectfully, I disagree with my opposing counsel's characterization that Texas courts have ever held that a sexual assault claim can be arbitrated. The standard for unconscionability, and this is where I think we differ, what my opposing counsel noted, the standard for unconscionability, she said, well, we had all of these clauses in there. We talked about that we could choose arbitrators. That type of claim, or that type of arguments regarding scope, that goes to whether we have a valid agreement. The test for substantive unconscionability is there a legitimate commercial reason justifying the inclusion of this term?
So you're asking us to adopt a per se rule that if the claim involves sexual assault, no matter what the contract says, it's not arbitrable.
Your Honor, this court can, without adopting a per se rule, can repeat this court's own jurisprudence as well as that of the Texas Supreme Court and note that arbitration clauses are determined, the unconscionability of arbitration clauses is determined on a case-by-case basis.
As of the time of the contract is made.
Correct, Your Honor. And the long story short is this court doesn't have to go so far as to say sexual assault claims can never be arbitrated, although I think it should. But the point is that following the court's jurisprudence, it can certainly say on a case-by-case basis, we don't believe it should apply here. Now, consider this. If we look at, is there a legitimate commercial reason for requiring a sexual assault claim to be arbitrated? I respectfully submit no. The Jones case went through in great detail why it should not. But my opposing counsel has referred to the Jones case in the context of the Sewell case from the 13th Court of Appeals, which they have categorized as a sexual assault case. And I think this, really quickly, Your Honor, my timer never started, so I have no idea where I am.
I'm sure you
I looked down and saw 20 minutes, and I'm like, you got to be kidding me.
I think you have about 2 or 3 minutes.
Yeah. How much longer do you want to hear me talk, I guess is it?
I'm sure you won't run over 20 minutes.
All right. Sounds good. Thank you. There was a case the Texas Supreme Court decided 2 years ago called BC versus Steak and Shake. And that case, I think, is central to how this court should rule for 2 reasons. One, BC versus Steak and Shake involved a low-level employee that was assaulted by her manager in the workplace. The argument in that particular context was the manager was a vice principal, and therefore his intentional torts bound the company treasury, and that she could sue the company for sexual assault because corporations only can act through their principals, officers, and vice principals. The defendant in that case made several arguments, one of which was this is a comp claim because it arose out of the course and scope of her employment. Another was that this is really just a claim for aggravated sexual harassment, and therefore you didn't satisfy your administrative remedies. And frankly, I don't remember the third one off the top of my head. But the long and short of it is the Supreme Court looked specifically at the difference between sexual harassment and sexual assault. In 2010, there was a Supreme Court case called Waffle House versus Williams. And in that particular claim, again, we had a low-level employee that was complaining about the actions of a coworker, and the allegations gave rise to what they called sexual harassment. In other words, unwelcome touching, inappropriate comments, suggestions of quid pro quo for sexual-related activity. And the court said, the plaintiff in that particular case sued both made a Title VII type claim, but also noted that occasionally the plaintiff would rub up against me or bump me inappropriately at work, and that was an unwelcome touching. So therefore, that was an assault. Went to trial on the assault claim, got all of the other evidence in, and got a very, very large verdict. And when it went to the Supreme Court reversed, and they said, well, wait a minute here. What you've basically done is pled around Title VII. What you had was a sexual harassment claim. You weren't really complaining about the assault. You can't dress up your pleadings to make what's arguably a statutory cause of action for harassment and say that, because there was an incidental touching, I can avoid that administrative scheme. In BC versus Steak and Shake, they said there's a clear difference between that type of a complaint and a claim for sexual assault, which is a crime under the Penal Code. And noted specifically, for example, if the manager at Steak and Shake had walked into the restroom, and shot the employee with a pistol, there's no question that she could hold the company treasury for aggravated assault, or treasury liable for aggravated assault. And the idea that because he tried to rape her, that somehow an administrative scheme is necessary, we're going to call this harassment instead of assault, was pure nonsense. So in Steak and Shake, the Supreme Court recognized the difference. IMFG Securities versus Sewell is a sexual harassment claim. There is an allegation of assault in there. There is no allegation of sexual assault. This term does not apply. You can look through the opinion. The words sexual and assault never appear together except when talking about the Jones case. And in the Jones case, they basically made a distinguishing factor. They said, in Jones, the circumstances were so egregious that they didn't require arbitration. We don't have that here. But in this particular case, this case is like Jones. It is not like Sewell. She's not simply alleging that Mr. Magnuson made inappropriate comments or threatened to fire her if she did not perform certain sexual acts or gave her a hostile work environment of some description. She is alleging civil damages for rape or sexual assault or however you want to categorize it. That is a different allegation than sexual assault, than sexual harassment, and it should be treated differently by this court. The other reason that this is an important distinction is that the claim for sexual harassment, as the Supreme Court noted in the Waffle House case, arises out of a statutory cause of action under the Labor Code. There is state agencies that are designed to look into these particular claims to give you even pre-clearance to sue in the first place. A sexual harassment claim does arise out of the conditions of your workplace. And this is important for two reasons. One, because the only bases that you could bring a sexual harassment claim are for quid pro quo, in other words, I get something for what you promised me, or alternatively, creating a hostile work environment that creates a constructive termination. But there's an affirmative defense under the statute in the Labor Code when you have a sexual harassment claim that allows the company to escape liability simply by showing that they made a prompt remedial measure to end the termination. If we were to say that a sexual harassment claim can be subject to arbitration because it's equivalent, a sexual assault claim can be subject to arbitration because it's basically the same thing as a sexual harassment claim, that would essentially allow a corporation to say, you know what, you have no claim against us because as soon as you reported the rape to us, we fired the assailant, and you're welcome to keep your job. There's simply no public policy behind that. If a principal, an officer, or a vice principal of a corporation sexually assault their employee, the corporate treasury is on the hook. There's no question about that. That's the state. So the fact that there is a claim here against AFC and saying that this assault took place in the workplace, even though work wasn't being performed at the time, does not mean that the arbitration clause or the arbitration clauses in these contracts are triggered. To the contrary, this court can rule in two ways. Well, three if he wants to go on my procedural grounds. Procedural grounds, second, that the scope of the contract does not cover any type of sexual activity, whether consensual or non-consensual. And third, even if it did, such a construction of a term would be substantively unconscionable because, using the Supreme Court's own language, there is no legitimate commercial reason justifying the inclusion of such a term. In the absence of any other questions, I'll rest on my brief, Your Honors. I see I have 20 minutes left.
Yes, you do. I have plenty of time.
Thank you, Your Honor.
Okay. I'm fairly sure you got that done in under 20 minutes.
Thank you.
Whenever you're ready.
I want to quote directly from the Jones versus Halliburton case. And this is the Fifth Circuit speaking. We do not hold that as a matter of law, sexual assault allegations can never relate to someone's employment. The FAA does not exclude sexual assault from the types of claims that can be arbitrated. Congress has had 4 times in the past 10 years that it could have amended the FAA, and it has not. And in fact, these bills have languished in Congress. There's one before Congress right now. To say that the court should make a per se rule that sexual assault can never be arbitrated would go beyond the scope of the law it is today. As I said in the beginning, arbitration agreements are creatures of contract and must be read within the confines of the agreement and the language that the parties have written down.
Speaking of that, let me just ask you out of curiosity. The enforcement provision says that this NDA will be enforced in accordance with the laws of the state of Texas.
Absolutely.
Is that what you're proceeding under here?
Well, according to the law, the FAA is part of Texas law, and it is part of Texas arbitration law. And to the extent that any Texas law would not allow an arbitration to be enforced, it is preempted by federal law. And that's what we have here. So going back to my concern at the beginning.
Well, I'm not sure I agree with you on that. That's a debate for another case. I was just curious because, why that issue wasn't raised below. I didn't know if there was something I missed there.
As far as what jurisdiction this came under?
Whether or not this is under the Texas Arbitration Act or the FAA.
It was not raised, Your Honor. No, nor was it raised by Ms. Nevarez. Counsel said that once the business ended, that's where the arbitration agreement ended. And that was my concern here at the beginning. We're now not reading the terms of the agreement. And I understand your concerns about the scope, and I would ask you to read it broadly. Now we're into public policy, and we're asking for per se rulings about a very serious issue, but again, one that has, to a certain extent, been decided by the Fifth Circuit, that it can never relate.
Well, the Fifth Circuit precedent is not binding on us.
No,
but we can look to Ninth Circuit if we wanted to.
Right, and while counsel did, absolutely, if you read the Jones versus Halliburton case, it is a fascinating cross-section, and the Fifth Circuit does an amazing job of going through the case law. The issue is that it's not certain. And the Fifth Circuit is interpreting the FAA, which is what is before us today, and whether or not the agreement is enforceable. And like I said, to the extent that any Texas public policy or Texas law would stop that enforcement, the FAA preempts. And so what counsel didn't tell you is that half of the brief, or half of the opinion, is the cases where they have arbitrated sexual assault. Okay? And so it is not a matter of public policy that can never be arbitrated. That is not the issue before the court, because that's not what the FAA says. And yes, courts have disagreed for various and sundry reasons. And unfortunately, the cases that do discuss this oftentimes are not clear about why they made this decision with. And sometimes it's under the FAA, and sometimes it's under the state arbitration rules. But that's not the case here. Again, when we look at the four corners of this document.
So I know that Mr. Keita is not necessarily full force advocating this, but what's wrong with a per se rule when it comes to alleged criminal activity? Why does that go to the dark hole of arbitration, not disclosed to the public? What is wrong? I mean, there's this assumption that there's something wrong with that simply because because the Fifth Circuit has not established a per se rule.
I think it's not just the Fifth Circuit. I think you're right. What's wrong with that? Well, it's up to Congress to change the FAA, and they've had the opportunity to do it. They've only changed it once, which is the Franken Amendment from 2009.
Well, public policy and substantive unconscionability are recognized ways to avoid arbitration. It wouldn't take an amendment to the FAA.
True, but even Texas public policy doesn't eliminate intentional torts from being arbitrated. It simply raises the level of scrutiny in that it requires the signature of an attorney. So it's not against public policy, as you said. Sorry,
keep going.
It's not against public policy to arbitrate, as you've characterized it, a crime. And here, intentional torts, but she's not alleging a crime. She's alleging intentional tort. And so,
well, I understand. She's in a civil proceeding, and that's why. But this conduct that, if accepted as true, is a crime.
So is an intentional tort of assault. But there's no law that says you can't arbitrate that. And whether we agree on that.
No, I wasn't necessarily arguing with you in that respect. I'm just saying you approached the argument as if some per se rule is just totally radical or unthinkable. And to me, it's not.
Thank you, Your Honor.
Okay, thank you all. Appreciate your fine briefs, fine arguments, your tolerance for my poor clock keeping. With that, we are adjourned until 10 o'clock or until we come back in the court.